What's AIP?
API.
Asian.
Oh,
Okay,
I was
we're
thinking
live.
I'm like AAIP.
You're
I've never heard
live.
of it.
And
Good
we're live.
afternoon. This is the House Judiciary Committee, and we're already ready to go. It's April the 9th, 2021, about 4:15. We have a range of bills we're going to try and vote this afternoon. We're going to start with a couple bills, Senate Bill 74 and House Bill 88. House Bill 88 in its initial incarnation was Delegate Brooks's bill related to employee assistance programs for police officers. The committee has an amendment for this bill and for Senator Washington's bill 74 to seek to address a gap in House Bill 670 with regard to the mental health treatment. And I talked about this a little bit earlier this morning before we went to the floor. The language that would be added, and Dylan, if we could put it up on the screen, I'd appreciate it, but I'll read it while you're doing that. The bill would now read as follows. It would read, a law enforcement agency may not discharge, transfer, reassign, discipline, wait, no, that's not it. That's not the right one. I keep looking at the different one.
That's an old version.
That's an old version.
Do you want me to read the?
Yes, this is not this version. This is an older version because there were problems with a couple of the languages. But the language is, it's 632117. A law enforcement agency, and if we could take this one down, please, Dylan. A law enforcement agency may not retaliate against, penalize, or punish a police officer because the police officer has sought or received mental health services. The idea here is seeking to address officers who seek assistance, mental health assistance, and address the concern that they may have concerns that they would be penalized for that. Now, Claire, did I get it right this time? Is Claire still here?
Yeah, sorry. Sometimes I have trouble unmuting. I'm sorry.
You're all right. So each bill would, as amended, would just read that. It would seek to fill that gap that was raised on the floor by, I think, Delegates Arakan and Griffith. And then Delegate Kipke raised this as an issue as well. And so we're seeking to address that issue with this language, which would go independently to the governor. Let me put this box up. All right. Can I have a motion on the amendment? This first one will go on. Let's do the amendment to House Bill 88. We're going to do this twice, basically.
Move the amendment.
Motion. Is there a second?
Second.
All right. Now we'll do discussion. Delegate McComas.
Thank you, Mr. Chair. Just briefly, we're taking out may not discharge, transfer, and all that other stuff, right?
We're not doing that specific language. We're doing. Claire, do you want to just make sure I get it right? Claire, can you just please for the group?
Read it again.
Yeah, just read it again. I don't want to get it wrong.
A law enforcement agency may not retaliate against, penalize, or punish a police officer because the police officer has sought or received mental health services.
Okay, so my question is, they didn't want the words, those other words, because they may, I guess I would like to know the reason why we are taking the other stuff out and just putting in what you have, or is it because we're concerned that we might be tying the hands of law enforcement with all that garbage?
We're taking the other stuff out because I believe, and Claire can correct me, a lot of that other language was included in House Bill 670. So this is seeking to add, this language, but we can't obviously add it into 670 because it's sitting on the governor's desk. So this seeks to add that additional part that Claire just read.
But they're all in the same section, correct?
Yes, it ends up being in the same section.
So how's it going to get melded by a corrective bill or something?
It'll just be a section that's right next to that other section.
Okay, all right,
The assistance plant program provisions, that's actually in Senate Bill 71 now. And so this would just be another section, right, adjacent to that. And it would apply not only to the employee seeking mental health services through the employee assistance program, but any type of any means of seeking mental health services.
okay.
Delegate Griffith.
I was hoping you could put the amendment on the screen, please.
Again, this is the amendment 632117. He there were, we were trying different iterations to be sure to get this right. And so there was a previous iteration, but now we're on to this one. Dylan, can you find it? Do you have it?
I have it up on my screen. If you can screen share, if you can let me, or I can send it to Dylan.
Yeah, why don't you send it to Dylan and then he
Yeah,
can-
why don't you send it over?
Yeah,
Okay.
send it to Dylan. We can go from there. One moment, please. There we go. And there we go. And we'll make it a little bigger. Okay. Can everybody read it? Yeah. This is what we're seeking to do. That is what the amendment would do. Are there further questions about the amendment?
Move favorable.
Motion for motion on the amendment.
Second.
And there's a second. Okay, Delegate Bartlett.
One quick question. And I know this is an amendment, but I don't see the word solely in there. Does that, not having that word solely, prohibit an officer being penalized or punished just put it this way, Claire, this is my question. So is the word solely necessary? That's my question.
Claire, is a question for Claire. You're asking whether it should say a law enforcement agency may not retaliate against, penalize, or punish a police officer solely because the police officer has
Yes,
mental health services?
yes.
Well, we did discuss that when drafting this language. And I mean, we discussed the language extensively. That's why there was that previous draft, which we decided not to go with. But we feel that this is best because even if a law enforcement agency is penalizing a police officer in part because they sought out mental health services, that's not good.
Right. Okay. I support the amendment. I was just wondering on that.
Yeah,
one. Thank you.
And I think that's exactly right. We don't want that to be a reason why. They can do it for other reasons, but we don't want it be for that reason. All right, so now we'll go on this amendment. So again, what's happening here is this is becoming effectively the bill. So all in favor of the amendment, this is on 74. All in favor, please raise your hands. Bartlett, Griffith, McComas, Conaway, Moon, Shetty, Lopez, Cardin, Grammer, Williams, Cham, Jones, Davis, Watson, Atterbury, Arakan, Crutchfield, Malone, Fisher, Cox. Anybody opposed? I think everybody was there. So I don't see anybody opposed. The amendment is adopted. We will, let's do this. We'll take a vote right now. It'll be a little out of order, but we'll take the vote now. Same amendment, doing the same thing to,
I'll move it again.
yeah, well, moving it again on House Bill 88. All in favor of making the same amendment, doing the same thing to House Bill 88, raise your hands. Delegates Bartlett, Griffith, McComas, Conaway, Moon, Shetty, Lopez, Cardin, Grammer, Williams, Cham, Jones, Davis, Watson, Atterbury, Malone, Arakan, Crutchfield, Fisher, and Cox. All right, nobody opposed. Okay, and so here's what we'll do. By unanimous consent, I'll say that the vote on Senate Bill 41 is going to be the same as the vote on House Bill 88 because we kind of just did this. Does anyone object to that? Does anybody want me to read the roll twice? I have dulcet tones. Some people tune in just to listen, but no? Okay. That's fine. So we're on both bills, Senate Bill 74 and House Bill 88 as amended. Favorable, could I have a motion on both bills as amended, please?
Move the bills as
Favorable.
amended.
All right.
Second.
Second. Any further discussion? Both bills. Vice Chair,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes, can I explain my vote just for 10 seconds?
10 seconds.
So as somebody who's both law enforcement and in the Marine Corps, this was such a big issue on both fronts where it was such a big stigma not to allow us to go seek this help, or not we're allowed to, but it was a stigma to it. This is going to help solve a lot of the problems we're trying to address this year. So I'm proudly supporting this bill.
10. All right, great. Good job. Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yeses.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
That's 20. So those will go to the floor. All right, now start with Senate Bill 201. All right, we heard these bills a long time ago, it seems like. I think everything feels like a long time ago at this point. What this legislation would do in Senate Bill 201, as it was amended in the Senate, is it would allow for the prospective expungement of records if a criminal charge ended up in an acquittal, a dismissal, a not guilty, or a null pros. The issues that were raised by the State's Attorneys Association were addressed by the actions in the Senate. They addressed the issues that they had. One of the issues was, I think, as the bill came in, it changed the length of time before you could request an expungement. This just addresses moving expungements moving forward for those things. So
Bill.
this is a straight favorable, and there's a motion on the bill. Is there a second?
Second.
A second, and we'll go to discussion with Delegate Arakan.
Thanks, Mr. Chair. So I see we've had this bill before, I think, or some version of it.
House Bill 238, which you're going to see next. House Bill 238 is the House version that didn't move before crossover. So it's on your list coming up.
Yeah, so I guess my concern is a lot of crimes that I personally, and I think my constituents believe should not be null prossed, keep being null prossed. And I don't know if I feel comfortable having something automatically expunged. I mean, look, we just said that even, exonerated, police violations are going to be available to the public. But now at the same time, we're saying, I mean, we see like repeat gun crimes being null prossed in our state. So, I mean, there's a lot of cognitive dissonance going on. So either people who are null prossed and are essentially innocent are so, and in which case we would expect to see parity across the board between civilians and officers, or they're not. And we want to see the collection of people's backgrounds, whether they were null prossed or whether they weren't. So I'm going to be red on this because I don't like the lack of parity that we're jumping into in the state right now.
Delegate Cham.
Thank you, Chair. So to understand correctly, this is for people who have committed crimes, but they have been acquitted or the charge has been dismissed and it's immediately.
No, it would be after 3 years. So this would just say that they, I think I've got that right. And I'll go again to council just to make sure that I've got that right. I believe that this just says that it shall be expunged 3 years after a disposition of the charge. If the charge in the case resulted in a disposition other than acquittal, dismissal, a not guilty, or a null pros. In other words, the regular process has this going away after 3 years. So instead of having to actually go and file for the expungement, you would be able to get the expungement under current law. It would happen automatically.
Thank you.
Okay. Delegate McComas, then Delegate Griffith.
Thank you, Mr. Chair. Right now, I've used this before, like when you have cross complaints for assault and battery between spouses and they plead the spousal privilege and they both get dismissed and so you run right into the clerk's office after you leave the judge and everybody signs, that they want to get them dismissed or get them expunged. The question is you have to sign that form, which says that you waive any claims you might have against anybody. And that has to accompany it. Now, is that going to still be required? I mean, because that's really important because if you want to sue somebody, you couldn't.
On page 6, it says that the defendant's not present in court for the disposition, the court shall notify the defendant by mail of the, so in other words, if it's a null pros where they weren't in court, like for example, in district court, you get the state's attorney's office will just dismiss a charge by what, at least in this county, what's called a yellow slip. State's attorney signs it, turn it in, and your minor jailable traffic goes away. Your minor case goes away. So those people would get a letter in the mail saying your case has been null pros. You have to send in this form waiving your rights. If they didn't send in the form, I still think that they wouldn't be able to sue based on what happened there because they needed to take the affirmative step. If they're in court, there's a null pros. They do that right now. They sign the form for a null pros right then and there, and then it goes out. Furthermore, the concern I had with regard to a marital invocation, I was concerned. And I'll just put on the record, I was concerned that a marital invocation, the records of the marital invocation would not be able to be kept by the state's attorney's office. However, in another part of the law, that is protected and allowed to be kept within the state's attorney's office, as you're only allowed to do one marital invocation on a second-degree assault case. So I think those issues were addressed by the bill, and to go further, one step further, in my conversations with the state's attorneys, they pointed to on page 6 of the Senate bill where that language lives regarding the notice requirement for that they have to turn back in regarding waiver of rights.
Okay, I have another question. The
Yep.
the judiciary came in and said that it was going to cost them $15 million. And has that issue been resolved?
Let's try to keep Delegate Moon settled for this part of the conversation, but I spoke with Chief Judge Morrissey and they believe that they can handle this because they believe that they can do the technical work within MDEC to be able to do this automatically. You're muted, Sue.
I guess, so basically, did the bill get constricted because it's going forward that they don't have because where did the 15 million come from? Because
It's prospective, because it's prospective and they can do the technical fix. That's the thing that makes it cheaper. If they went back in time, that would cost a lot more money. But forward.
All right, thank you.
Forward, okay. Backward, harder. Plus PBJs were taken out. Delegate Griffith, then Moon, then Cardin, then we're calling the question. Delegate Griffith.
Griffith. Thank you.
Griffith. Delegate expungement, I think he said he was in a previous.
Well, I'm hoping to vote for this, but I have some questions first. Honestly, I'm hoping to vote for this for a variety of reasons, which I will explain. But my first question is, what are the most, so this is automatic expungement after 3 years?
If it is an acquittal, null pros, dismissal.
So what are the most severe crimes that would be caught up in a null pros? Like what severe? I mean, like what's the most severe crimes that could get, unintentional, like multiple gun crimes or things of that nature. Like I honestly don't know.
I'm going to ask Claire. I mean, because I just want to be sure that I'm getting this right. This isn't the limited. Is this limited, Claire, to the crimes that are already in the expungement statute?
No, I mean, it could be murder.
Yeah, it could be all crimes, any crime. But again, they would have had to have been acquitted, dismissed, not guilty, or null pros. So in other words, they were found not guilty. They were dismissed by the state.
What are the unintended consequences of this?
Was it Secretary Rumsfeld says there are known unknowns and unknown unknowns, and I on this one, I mean, look, I
want to vote for this, but I don't want to do something that's going, I don't want to do something to back me.
No, I understand the reticence. I mean, I think, if a person was found not guilty, then they went through the whole process and they couldn't prove it beyond a reasonable doubt. So that's an expungement. If it's an acquittal, same thing. So it usually happens in the middle of the case. If it's a dismissal or a null process, the state's attorney determined that they didn't have enough to go forward, or they had some other reason not to go forward. So
a person can already apply to get these things expunged. This is just saying it's automatic in these particular circumstances. So it's not giving a person the right to get an expungement that they don't already have.
Right.
Well, and my last concern and my biggest concern, again, it goes back to the conversations over the last week, where we took this right away from law enforcement and going to extend it to citizens. And why isn't this something that's fair across the board for everyone? If a police officer was acquitted, if a police officer in the police bills, if the person who made the complaint admits that it was not a real complaint, admits they were misleading, it still sticks on the record. So it's that's what is most disturbing to me about this whole thing. And I'm going to put my money where my mouth is. I'm going to vote for this, but I also want to I want to take away the fact that we're not extending this to law enforcement in the exact same situation.
I understand. We'll go now with delegates Moon, Cardin, and Fisher.
Thank you, Mr. Chair. I was just going to say this was unanimous across the street. Move the previous question.
Let's give Carden and Fisher a chance, unless Fisher was going to move the previous question too, but we'll go to Carden quickly and then.
Thank you. So Claire
Question after
said
Fisher.
the first thing, which is that people are already entitled to this. This is just going to be automatic. Is that correct?
Right. Correct.
Okay. And you had indicated very quickly, Mr. Chair, that this would happen after 3 years. But if it's a dismissal, it's not 3 years. I mean, you're entitled to it immediately.
Right. I mean, that based on what the bill has laid out. And so for going forward, I believe it would be.
I mean, I think maybe what you're saying is that if it's going to be automatic, if you don't request it, it's going to automatically be done within 3 years, is I think.
Yes, correct. It's going to automatically happen.
Which means that if you do it proactively, as Delegate McComas was talking about, you can sign that waiver. But if you don't sign the waiver, they're essentially going to wait for that statute of limitations to run before they do it. Which I think
effectively.
And I think that's the reason why they're giving themselves 3 years. So I just want to explain that so it makes sense that they're kind of covering their own bases. And I also, the last thing I want to say is, it seems like the judiciary, who had seemed to always have problems with this in terms of costs, is now on board. I think it's great. I would suggest that Delegate Moon's suggestion after Delegate Fisher goes is the right way to go. And let's just vote this thing.
Well, Delegate Fisher lowered her hand, so I think that you made Delegate Fisher's point, so that's fine. We're on the question. There's a motion for a favorable. It's a clean vote. We'll go and we will do the roll call. The Vice Chair?
Yes.
Erican?
No.
Bartlett?
Yes.
Carden?
Yes.
Conaway?
Yes.
Cox?
No.
Crutchfield?
Yes.
Deborah Davis?
Yes.
Juanica Fisher?
Yes.
Grammer?
No.
Griffith?
Yes, and to explain my vote,
Okay.
one, I do think individuals who've been cleared of wrongdoing should not have that haunt them. And I also hope that we're, as a body, next session, are willing to extend that same forgiveness and grace to law enforcement officers who also have done nothing wrong.
Delegate Rachel Jones?
Yes.
Lopez?
Yes.
Malone?
No.
McComas?
Out of respect for my colleagues, no.
Moon?
Yes.
I'm sorry?
Yes.
No. I thought you said pass. Shetty?
Yes.
Cham?
Trying to think about my constituents, and we have a prison there in Hagerstown. People get out, trying to get a job, can't get a job because of their record. Can I vote last? Still think.
No.
You can't. I'm sorry.
All right, I'm gonna say yes.
Okay. Delegate Ron Watson?
Yes.
Williams?
Yes.
15-5. So the House crossfile is House Bill 238, Delegate Wells's bill. There's amendments that would conform it to be the same as Senate Bill 201. Can I get a motion to conform the bills to?
So moved.
All right, motion to conform in a second. All in favor of conforming to Senate Bill conforming House Bill 238 to Senate Bill 201, please raise your hands. Delegate Carden, Fisher, Griffith, Conaway, Bartlett, Erican, Grammer, Lopez, Shetty, Williams, Jones, Atterbury, Watson, Davis, Crutchfield, all opposed to the conforming amendment. Seeing none opposed, the amendment's adopted. We're now on House Bill 238.
Move the bill as amended.
Motion is amended in a second. We already discussed it. We'll go from there with the roll call. The Vice Chair,
Yes.
Erican,
No,
Bartlett,
Yes.
Hardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Sorry, I have the mute. Yes.
Grammer,
No.
Griffith,
Yes.
Jones,
Yes.
Lopez,
Yes.
Malone. Malone? Did we lose Mike Malone? We lost Mike Malone. McComas,
No,
Moon,
Yes.
Shetty,
Yes.
Sham,
Yes.
Watson,
Yes.
Williams.
Yes.
Is Delegate Malone in the lounge, in the waiting room, in the thing?
No, he's not. I shot him a text.
Okay, hopefully we'll get him back. That was 15-4. All right. Senate Bill 187. This is the cross file of Delegate Shetty's bill on genealogical DNA analysis. There's a motion for a favorable.
Second.
Second.
I'm sorry, which bill is this, Mr. Chair?
Senate Bill 187.
Senate bill. I'm sorry, give me 1 sec.
Mr. Chair,
Yes, Delegate
I
Bartlett.
have 6 amendments I'd like to put in, please.
Okay.
Mr. Chair, I just want to say on every single thing we vote on from here on out, I'm going to explain my vote and it's going to take 5 minutes for each time I explain my vote, okay? So we should build that into the time.
And I'm gonna ask 1,000 questions on things we've already had hearings on.
Okay,
I love all those ideas, by the way.
Can we just play nice in the sandbox?
We know you do.
Let's play nice in the sandbox.
Mr. Chair, I have a question. I guess it's a point of order, Mr.
I thought you might, Delegate Grammer.
I have an amendment. I thought I sent it. I'm not sure if I sent it, and it would,
I don't have it.
okay.
Do I think we know what the amendment would have been?
It's just, it conforms it to the House version.
I
I'm
don't,
confused. Was this on our vote list? I don't even have this listed.
I didn't see it, or I would have sent the amendment, and
It's
that's,
on the list.
we have a motion for a favorable in a second.
It's not, it's actually not on the list. I have it on.
It is. It's on the website.
No, it's literally not. I'm looking at it right now.
You're looking at the 9 a.m. list. The 2:30 list has it.
Nope, this is the 2:30 list. It's not on there.
Dylan, it's my understanding that the Senate Bill 187 is in fact on the later list. Is that correct?
It was added to the hearing schedule at an earlier time this afternoon. Yes, I can't quite tell you exactly when. It's been
it was added later.
I see it on the list.
And I'd just like to say, Mr. Chair, I'm pretty sure as chair, it's up your discretion as to what we can and cannot vote on at any point in time.
That is in fact the rule.
Yeah, I'm not saying we shouldn't vote on it. I'm just saying, you know,
I understand.
he would have had his amendment in probably in time if we had known.
I'll ask
I'm
gently.
looking at it, it's still not here.
I'll ask very gently. Since it was added later, would you consider the amendment which passed the committee last time? I know.
You know,
I love you and I want you to remember that.
Yeah, I do see it on the website.
really?
I do really love you and all of you.
I understand that. Here's what I'm going to say. I just have to say that, well, I know Delegate Conaway, I know you want to speak. Give me a second. I think that Senator Sidner, I know that a lot of people work very hard on bills. I know that this is a bill that has taken 3 years to get here. And you know, I think it's in the posture right now where if we do not pass this bill, it won't become law. With due respect to Delegate Shetty, we hope to see her bill bounce back across, but there's entirely a chance that it won't.
Her bill's on the voting list.
Is it?
Yes,
If it
right
is.
next to mine.
Oh, in JPR.
Yes.
In JPR. Okay. Yeah. But that's kind of where my head is right now. Is we're running out of time here. But Delegate Conway had raised his hand quickly, and then we'll go to Delegate Shetty.
Very quickly, Abel loved Cain, and what does love have to do with it? Let's get on with it.
Just wanting to make sure I heard that correctly. Abel loved Cain, and what does love have to do with it? Delegate Conway?
Yes,
I hear
yes,
that
that's
correct?
correct. That's correct.
All right. Delegate Shetty, briefly, if you would like.
Very briefly, Mr. Chair, just an update that this morning JPR amended my bill to conform with the version of the bill that Senator Sidnor has before us right now, this moment. So if we further amend this, it could either die or it'll go to conference, and we will likely end up with this version anyway. So I would please kindly encourage my colleagues to consider voting favorably on the previous question.
Move favorable.
All right, there's a motion for a favorable, and I think a second.
Second.
Got it. We're going to hear discussion now. We're already, I think, there, but anyway, Delegate Griffith and Delegate Eric.
Just very briefly, what does the amendments do as conformed to the Senate version?
I think you can say, Delegate Grammer, what the amendments would
So
have.
the amendment, if you remember, it added kidnapping and human trafficking.
No, is that the amendment that, what I'm asking is, how it conforms to the Senate version? How is it different?
So what happened is Delegate Shetty's bill got amended in the Senate back to its original version. And this bill got added later in the day, so I didn't realize that we were voting on it, and I didn't get my amendment to the committee.
Delegate Arakan.
Is that the only change the Senate made? Maybe Emily can answer that. Delegate
Go
Shetty
ahead,
can answer
Delegate
that.
Shetty.
Yes, the only difference between the House bill that we passed and the version before us right now is Delegate Grammer's amendment, which added kidnapping and human trafficking. So, and we have circled back with all of the advocates that we worked with. They have all confirmed that this is not an amendment that they would support. So please consider passing Senator Sidnor's bill as introduced or as before us right now.
I mean it genuinely with respect to Delegate Grammer. I mean it with respect. I think that, again, the larger issue, we've dealt with this larger issue for 3 years. I think they've gotten to a place where advocates are happy. I understand if you're going to vote against the bill, but the motion is for a favorable. There has been a second. Seeing no further discussion on the bill, I'm going to call a roll call. The Vice Chair,
Yes.
Delegate Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conway,
Yes.
Cox,
Yes, and I just want to say I'm very proud of Delegate Grammer for trying to protect those with the additional language. It's sad that it didn't get kept in the bill.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanica Fisher,
Yes, and thanking Delegate Shetty for all her hard work on this, and Senator Sidnor. It was a journey.
Delegate Grammer.
Yes, and to explain my vote briefly, really disappointed. We got introduced the bill and said, here it is. And then it's kind of like, oh, we got to vote on it. We supported a very small amendment. Now here we are, at the end of the session, this bill wasn't on the calendar. It gets added on the calendar, and surprise, the Senate has wound back our amendment. So I understand even when we lose, and that's fine. But just to be given the opportunity to talk to people about changes, it would be very good going forward. Thank you.
Delegate Griffith,
Yes.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
Yes.
Delegate Ron Watson,
Yes.
Delegate Williams.
Yes.
That's 20. Okay, we're going to go now to, and I'm sensitive to the time, Senator Klossmeyer's bill. All right, this is Senate Bill 515. During our programming earlier this morning, we assigned a conference committee to House Bill 48, which was Delegate Bandari's bill, and it was his crossfile on this bill. We set up a conference committee. We have this bill here now. The Senate made 2 sets of changes. And I'm going to go to the bill, and then if Dylan, if you want to put up the amendment 552618. I'm going to describe the amendments to the amendments that the Senate made to the bill. We said in our bill that the registrant who's a student shall continue receiving an education in accordance with state law by either participating in the home and hospital teaching program for students or attending a regional institute for children and adolescents. And we added the option where each county board shall develop and adopt a policy that enables a registrant who is a student to continue receiving an education as described under paragraph 1. Our intent was to say, okay, these kids still have a right to receive, they're not really kids anymore, but they're on the sex offender registry. They're over 18 usually. They have the right to continue with an education and to get their high school education until they're 21. So we wanted to lay out those other options. The Senate created a third option, which is a non-public educational program as provided by section 8406 of the education article, if the registrant is notified an agent or employee of the non-public educational program that the registrant is required to register under the subtitle, and the registrant has been given specific written permission by an agent or employee of the non-public educational program to attend the non-public educational program. These non-public educational programs are, wait for it, not public. They're private programs. There is one that operates in the state. It provides generally special education services, but it does accept people who are on the sex offender registry and helps them get their high school diploma. So they added that part to the bill. I don't believe there's controversy about that part of the bill. The thing that they did change that after talking to Ways and Means in relation to how this would impact people's rights to an education, our language said, going back to the beginning, a registrant who is a student shall continue receiving an education in accordance with state law. So what they changed it to is a registrant who is a student may receive an education in accordance with state law. The concern of people in Ways and Means, this is not dually assigned, I'll say, but I consulted with Ways and Means. The concern with changing the shall to a may is that it might allow a school district to exclude somebody who is on the sex offender registry from getting a high school diploma. So the idea here is to kind of do a conference committee without actually going to conference and to amend Senator Klossmeyer's bill to take some of the Senate changes, to take the Senate change regarding the non-public educational program, but to say it really needs to be a shall as opposed to a may, to make clear that if they're eligible to go to school, they still should consider receiving, they still should continue receiving an education in accordance with state law. With that painful description of the bigger picture and what the amendment is seeking to do, let's go, and the amendment is on your screen and has been there for a while, and it is just that. It keeps the rest of the language. Let's go to questions from Delegate Grammer, then Griffith and Cox.
Oh, I'm good, thank you.
Okay, Griffith.
Real fast, something that went by pretty quickly. You said that some of these individuals would go to a program with special education students.
The program deals with basically with people with IEPs. So people who have special education needs or needs in special education. So
Right.
these kids are in special education anyway, and they have apparently, and the name of the program, I of course don't have with me, but the program does have they do already serve kids who are on the sex offense registry. So they are already wired to do it.
Well, I will drive right to my concern, and if my concern's not valid, please dismiss it. Someone on the sex offender registry being caught up in classes or in school with a nonverbal autistic child. That's the concern.
I understand that, and I asked about that. No, the program that in fact this language came from JPR, who found out about this program. Lauren, if I'm missing something, I'm sure you'll let me know. They heard about this program, and they have set themselves up to deal with that kind of set of circumstances, and that is not.
So they have guardrails on that concern.
They have guardrails on that. Yes.
Thank you.
Delegate Cox, then Delegate Fisher.
Well, thank you, Mr. Chair. So those guardrails, are they actually in the COMAR, do you know?
I don't know that they're actually in the COMAR. I know that they have those guardrails within the program that is operating.
Well, that would be my concern, because if it's just a program policy, obviously that has no force of law as the COMAR does, which should govern, I think, this to make sure there's guardrails. So I don't know if there's a way that the committee can make that express intent in the bill. I think adding this could potentially create a problem for that. The other part of it is Education 7-301 is already a shell for all students. The issue, though, is making sure that these individuals on the sex registry can be provided the education in an environment that is not necessarily the same as other IEPs. So I think that should continue. I don't think that they should be provided an equal opportunity to get into a situation with an autistic child, or if there's not adequate guardrails, or potentially create an additional burden to the system where they already have options that can make sure they're kept out of those potential environments while still receiving their education.
It's worth mentioning in the bill that came from JPR that they are required, that the registrant has been given specific written permission by an agent or employee of the non-public educational program to attend that non-public educational program. I would argue that they have received that permission basically the program is basically saying, we know who you are, we know you are a registrant, and we will act, we acknowledge that, and that kind of puts them on notice that they have to act appropriately. And again, there's also a requirement that the registrant has to notify the agent as well. So I think the other thing that I'll go back to in the language that we adopted, each county board shall develop and adopt a policy that enables a registrant who is a student to receive an education. They are in the county boards have to develop and adopt a policy as well. And so that can build some of those guardrails around the situation where you would put people, potentially autistic kids or others with special education needs in harm's way. Delegate Erican, the Delegate Cham.
So I think it's really concerning that we're essentially setting up the exact same policy that already existed in the regular public school system, where some person can just sign off and say that they understand this child as the adult. This is an adult, actually, 18 to 21, that's on the sex offender registry. They just sign off and then put that guy in a class with a bunch of nonverbal kids. No, No,
Not sure that it would be necessarily with nonverbal kids. That's not my impression of what the program is. I mean, if you'd like, we can get more information about the specific program if that would make you feel more comfortable.
yeah, I mean, this is like.
That's
I mean,
fine. I'm good with that. I mean, look, what we're trying to do here and what Delegate Mangione, Delegates Jackson and Bhandari and Senator Klossmeyer are trying to address is the situation that happened in Perry Hall. And we've been trying to address it now for 2 years. And I want to find a way forward. So if we can address some of those concerns and get more information about the program that they're talking about here, then I'm happy to do that. So I'm happy to do that, but I'll hear from Delegate Cham first, and then I'll move to the next bill.
so will you send it to conference then? Is that what your plan is?
So we've already got that done. So the Bhandari bill is already going to conference.
And how does that work when you have two of the same bill then? They don't both go to the same conference?
The idea here is with that bill going to conference, that bill up in the air going to conference, they could conceivably start working on that. However, if we manage to figure out if we make the amendment that's being proposed here and then the Senate accepts it, then we're done. Basically, the long and short is, if we can come to a conclusion without actually having to go to conference, we have a vehicle right here to be able to make the changes on this bill, and then the Senate just concurs. You see what I'm saying? We can make the amendments onto this bill and then the Senate concurs. So we have multiple ways of getting this done, so we can try and figure it out one way or the other. That's what I'm trying to do. Delegate Cham.
Thank you, Chair. Is the program that you're thinking of called RICA? Regional Institute for Children and Adolescents? I don't know if that's the program that
I think, but we'll get the information, and I think that's what I heard.
But one last thing too, just for the sake of some clarity maybe that's needed. I mean, all of my special ed experiences, well, most of it has been in the non-public setting and some public school experiences too. I've never, ever in my over 20-year experience as being a special educator, seen a school place a student with these type of egregious behaviors in a classroom with non-vocal autism or students with an intellectual disability. They will not program for kids like that.
And that is, I believe, what that catch-all language that I went to afterwards seeks to sort of acknowledge is the registrant has to tell them he or she is on the registry, and they have to kind of acknowledge, we know you're on the registry and we are taking you. So there's a kind of two-way street there that has to happen. But let's get, we're gonna keep moving. I understand. All right, we have an emergency meeting of the Black Caucus and Latino Caucus. I'm just saying, I have several more bills on this voting list, including the Senator McRae's bill Senator McRae's bill, Senator Patterson's bill, and again, Senator Carter's bill with regard to pensions. My inclination is to
let's keep going.
Go forward. Yeah, Senate Bill 525. Senate Bill 525, we heard value my vote. That was House Bill 222. House Bill 222 is, it's difficult to say what posture it's in the Senate. I think it may be moving out of the Senate, significantly different. In discussions, there's discussions to have Senator McRae's bill changed from a Baltimore City bill into a statewide bill. And the bill would enable a ballot drop box at any correctional facility with a capacity larger than 50. So in other words, this would be any local detention, I see you, Delegate Conway, any local detention center. It would not be the single cell at the Eastern District for Anne Arundel County. It would not be the 5 cells at the Annapolis Police Department. It's the smallest county detention center, at least the ones that I can figure out, is in Garrett County in Oakland, where there's a detention center with 65 people is the maximum capacity. It would require the ballot drop box. It would require signage regarding election materials, and it requires the local board of elections to provide election materials to voters or people who are eligible to vote inside those detention centers. That is what the bill, the amendments to Senate Bill 2525 would do. As it came in, it was only a Baltimore City bill. I think I heard Delegate Moon move the amendments. Is there a second? All right, now we'll go to Delegate Conaway.
Thank you, Mr. Chairman. I was wondering, since you know that this is an emergency meeting and it's Black Caucus and Latino Caucus and Asian Caucus, I mean, how are you just going to overrule us going to those caucus meetings? I mean, can we take a vote on whether we're going to stay or not? I mean, you might have enough members of the 3 or 4 different caucuses that want to go or need to know what's going on.
I understand that. I think
The agenda for the emergency meeting is out there, Delegate Conaway. You can take a look, and if those items are important to you, then by all means do what you got to do. But I think we need to press forward here.
Okay, well, I hadn't seen that, so I'll take a look at it, and thank you very much.
All right, thank you. Are there further discussions on the amendment as has been described? All right, so on the amendment, all in favor of the amendment, please raise your hands. All right, I see delegates Cardin, Bartlett, Fisher, Moon, Lopez, Shetty, Williams, Atterbury, Watson, Davis, Jones, Crutchfield. All those opposed to the amendment, please raise your hands. Delegate Cham, Grammer, Griffith, Malone, McComas. All right, and Cox. The amendments are
Favorable.
There's a motion for a favorable on the bill as amended. Is there a second?
Second.
And a second. All right. Is there further discussion on the bill? Seeing none, the vice chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Protestingly, yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher, she may have already left. Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Watson,
Yes.
Williams.
Yes.
Right. Looks like 12-7, the motion passes. Right. All right, I have Senate Bill 800. Senator Obie Patterson's bill related to training. It sets up a pilot program for a year before an inmate is to be released. It would work with pilot programs at several state universities and allows MHEC to establish additional pilot programs with institutions through a memorandum of understanding. There are no
Move favorable.
legislation. The motion is for a favorable. Is there discussion regarding the bill? Delegate Eric.
For some reason, I don't remember this one. Did this bill go through subcommittee?
No, this bill was heard. It was Delegate Proctor's bill. And it was relatively, I think it was not long before crossover. When we heard.
So, but did the Senate bill, was that one heard? Did we hear that?
The
Senate bill passed unanimously, is my understanding.
And because.
Yeah, no, I mean, in our committee, I just don't remember hearing it in our committee. It was Senator Patterson, you said?
Yeah, Senator Patterson, but we had the same bill in the same posture, and the rule is set with by the speaker was that since it was a bill in the same posture and we had a hearing on it, we didn't have another hearing after crossover.
Gotcha. It's a pretty dense bill, so I guess I'm surprised it didn't go through a subcommittee, but there's some letters of information in there from MHEC, and basically it looks like that they state very clearly that they're not well suited to provide the follow-up that's required in the bill. I don't know if that was edited out, but it says the hotline and connections to other nonprofits. That was MHEC's concern. And then DPSCS said that they've just started their tablet pilot, and that right now the Department of Labor handles all of the correctional education stuff. And so they had concerns about implementing a lot of the bill. Was any of that addressed?
The language regarding access to the internet was stricken from the bill, so that language that would ensure internet access was in fact taken out of the bill.
Okay, and anything that removes MHEC from being.
Oh, and we actually did, Claire Rossmark just reminded me, we actually did have a hearing on this bill on April the 1st.
Oh, good. And did we take MHEC out of it so that they didn't have to be the ones doing it?
No, MHEC is still in charge of the bill, or in charge of setting up the program.
On the
Budget.
Chair?
Hang on one second. There's actually money in the budget for that.
Oh, okay.
In MHEC, okay.
On the purpose. Okay. On the purpose graph, MHEC is crossed out.
I'm pretty sure that they remain, but I'll double check and go through the bill again.
Yeah, they just said that they weren't the best suited, and as of right now, the Department of Labor handles all of this stuff.
Right.
So I think that they were a little confused why they were included when we already have Department of Labor doing the exact same thing. It just doesn't make a lot of sense. So.
I understand. Delegate Griffith has a question, and I'm going to come back to Delegate Erican's question.
Real briefly, so we have not voted on the House cross file of this?
We have not.
So we're only working on the Senate version right now, okay?
We are on the Senate version.
All right, thank you.
Given where we are in session, that's kind of what ends up happening here as we get a little later. Delegate Cox, then Delegate Cham.
Thank you, Mr. Chair. I didn't recall the bill either. I just wanted to clarify as I was reading it, the reprint from the Senate. Is this a free program for 1 year only? And then it said something about an extra stipend that will be paid. What amount is that per person? And is there any requirement to pay back the tuition, or how does this actually work financially?
The commission, by the way, is still in the bill. It's the Higher Education Commission. It is MHEC. You go to the stipends provided to student members is provided for in the funding. It lists the maximum funding at $300,000. And that is what I understand is in the budget for the program.
So it's a small stipend in addition to the free tuition for a year, pretty much? Is that the way I'm reading it?
I think that, I mean, it is the idea here is it's a broader it's providing educational and vocational training opportunities. I'm not sure that it's, well, I guess you could argue it is paying for tuition, but it's providing educational opportunities in the 12 months prior to release to put them in a better position when they are released from the facility. They have to take courses through a suitable format that are credit bearing and count towards a degree, certificate, or a license. Delegate Sham. And it does say, as Delegate Bartlett indicates in the chat, that MHEC will handle the hotline. Delegate Sham.
Thank you, Chair. So reading the bill, is the current pilot program only located at this training program located at only these 4 universities, if I'm reading that correctly?
I think that you're reading the part where it talks about the governing entities. In the bill, it also talks about how MHEC can also work with other post-secondary institutions as well. And it says that in the governing entity, so it is beyond just Bowie State, Coppin State, Morgan State, and UMES. It can also be any other location where the commission establishes a pilot program under 24.1302 of the subtitle.
So, and please forgive me if it's
fine.
Ignorant question, I apologize.
They're not. No.
Okay. So with people who are inmates who are not in these areas, like for instance, Hagerstown has a prison, how would they access this type of program?
Well, it says also, and I missed this part on page 4 of the bill, the very top, the commission may establish a pilot program at an institution of post-secondary education not listed. So an institution that's not one of those 4. So in Hagerstown, you could conceivably work in coordination with another institution, another post-secondary institution, which could conceivably, I would think, include the community college, maybe Hood College.
Right.
Or no, Hood College is in Frederick County, am I right?
Right, it's Frederick.
Yeah, so I apologize for that. I got geographic bubble in my head. They could get in work with other jurisdictions. I mean, the point that I was making when I first started to read the bill is one of the biggest institutions is Jessup. And if it were only limited to Bowie, Coppin, Morgan, and UMES, the one that's closer to Jessup obviously is UMBC. So the language would allow the commission to set something up with that institution as well.
Thank you.
So it allows some flexibility. Delegate Malone.
So as I see it,
Can you turn your video back on?
Yeah, as I see it, it looks like it's focusing at colleges. Can the pilot program cover any of the trade schools, or is it really just focusing on 4-year institutions?
So the pilot program, again, it is, I'm trying to remember, I know that it was not solely listed, connected to either a series of courses or lead to an industry recognized certificate or license, which could be something that would be separate from what you would get, a degree that you would get at one of those places. And a lot of those programs already exist where they at least have curricula in some cases to give people training with some of those external entities. And I think I remember when we went to Jessup, when we went to the women's facility, they had the CAD training in the women's facility, and that I think led to certification there too. So there's some of this that's already happening, but this would build a deliberate, it would be piloting more of a deliberate program going forward.
Do we know if it's going to be done in person or can it also be done virtually? I know there was a professor from UB that submitted testimony that had concern about virtual.
The bill indicates that the courses and instruction are provided in a suitable manner and that they would determine whether the instruction would be virtual or not virtual. That they have to create a safe and reasonable process, whether virtually in person, by which to confer a degree as well. So the idea, I think, is to develop a hybrid virtual and in-person learning environment. That is on page 6, lines, well, pretty much 1 through 7 to deal with the kind of the way about it, the curricular way forward in that way, on that issue, I should say. All right, we're on the bill. There are no amendments to the bill. I believe we have a motion for a favorable and a second.
Second.
Seeing no further questions, we'll go to roll call. The vice chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Delegate Carden,
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
No.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher,
Yes.
Delegate Grammer,
No.
Delegate Griffith,
Yes.
Delegate Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
No.
Delegate McComas,
No, and just to explain my vote, we had a letter from the Barbara Wilkins, who works for Budget and Management, and they're concerned about the cost. Just,
right? Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
No.
Delegate Ron Watson,
Yes.
Delegate Williams.
Yes.
All right, that's 14-6. I'm gonna go now. There are a couple things here. This is a Juanita Fisher bill that we are going to concur on, and it's connected to Senator West's bill, Senate Bills 820. Senator West's bill, we're going to concur. We are going to amend Senator West's bill to conform to the form that the Senate amended Delegate Fisher's bill to look like. Everybody got that? The Senate amended Delegate Fisher's bill. We have the Senate bill that they had actually amended in a different way, and there were errors in it, and correct me if I'm wrong, Polly. She's not answering, so hopefully.
No, you're correct, Chair. That's right.
That's fine. So there are multiple balls in the air here, basically. So Delegate Fisher, can you tell us what the bill we're conforming to here? That is House Bill 1261. And the motion would be to concur in the Senate's amendments. What were the Senate's amendments, and what's the bill do now?
Delegate Fisher, I can help you too if you need it. And we have the amendments if we want to show the committee, so.
If you could, Holly, I apologize. Mr.
That's
Chair,
fine.
No,
this was right now.
This is a tricky one, so you're fine. There was a lot of moving parts here. So we're going to amend Senate Bill 820 to basically just change the method in which a will, power of attorney, and advance directive may be executed. All we're going to do is clean up the language of a couple definitions, specifically with the electronic presence, and we're going to carve out a section for real property. They wanted to have an exception for any recording of an instrument under the real property article, and then we take back the special enactment section and have it date to March 10th, which it was originally and was amended. So we're just going to take back the special sections and make it how it was in the House bill originally.
Okay. My understanding is that the amendments that we would be concurring to in House Bill 1261 have been agreed to by all of the parties in the Estates and Trust Law, that they've all gotten together with their estates and trusts and gotten together and they're good with this, correct, Delegate Fisher?
Yes, Mr. Chair.
And they've gotten together with you and with Senator West, and everybody is on the same page, correct?
We are all agreed and on the same page.
There's a motion to concur. Is there a second?
Second.
All right. All those in favor of concurring to the Senate amendments on 1261, please raise your hands. Delegates Conaway, Bartlett, Cardin, Cham, Williams, Shetty, Lopez, Moon, Jones, Davis, Watson, Atterbury, Fisher, Crutchfield. Anybody opposed? Seeing no one opposed, the amendments are, well, the motion to concur carries, and that's what will go to the floor. Now, Senator West's bill has amendments that would conform Senator West's bill to House Bill 1261, fix the problems that were identified in Senate Bill 820. And so then everybody, we believe, is happy. There's the amendments to 820 that will do as what was described. Can I have a motion on the amendments to 820?
Move the amendments.
Motion on the amendments in a second. All in favor of the amendments to 820 to now conform to 1261, please raise your hands. Delegates Cardin, Bartlett, Conaway, Moon, Shetty, Williams, Atterbury, Watson, Davis, Jones, Crutchfield. Anybody, and Fisher. Anybody opposed to conforming? Seeing none. The amendments are adopted to conform Senate Bill 822, 820 to the House Bill 1261. Can I have a motion on Senate Bill 820?
Move as amended.
Move as amended.
Second.
All right, moved and seconded. All right. Further discussion? Going to do a roll call. The Vice Chair,
Yes.
Delegate Erican,
I think she just left for caucus.
okay, Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
Yes.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanica Fisher,
Yes.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
William.
Yes.
That's 18. Last bill we have on the list
Mr.
is,
Chair, I need to step away for caucus, please.
so we have we do have the GOP caucus right now. And
Last bill.
this is the last bill.
We didn't break for the other caucus.
What is
Yeah,
it?
but this caucus was announced on the floor, so it was a known stop. Candidly, we were supposed to start at 2:30 and we did not. We could have started sooner. Things kept getting kicked later.
Can we just hear what the bill is?
Bill is the bill that would eliminate pensions for police officers, felonies during the line of duty.
With respect, Mr. Chair, this is an important bill we want to discuss. And caucus.
There was a lot of discussion this morning, I would say. There was a huge amount of discussion this morning on the bill, and it's clear that there are people who are going to vote against it and people who are going to vote for it. I don't have further amendments.
We could just take the vote, right? Keep it quick.
We could, because I was waiting this morning to make a comment for a very long time and didn't have a chance. So I'm happy to just vote on the bill.
Well, I'm rushing quickly to caucus meeting. Okay, thank you.
And I went through further to follow up on my questions I had earlier in back room. I'm still looking to know what is the definition of notice as far as noticing spouse. I went through the bill and I could not find a definition.
Has the bill been moved?
Matt, no, the bill is not.
I mean, with a lot of legislation, with a lot of laws that we have in the state, I mean, everything isn't strictly explicitly spelled out. It literally says, though, that notice of a complaint filed under this shall be served on everybody under 21804 subsection B2.
How served? Pursuant to what? There's different service rules in our Maryland rules.
I mean, I'm happy to, you could have addressed that to me a little bit earlier, but I'm
Well,
happy to go back and look at.
I mean, there's not a reprint on it. I did look at the amendment. I mean, I'll give you an example that I'm concerned about. Under the Maryland service rules, you can serve any adult in the household. The problem is also we've changed our divorce laws that people can now still be living in the same household. So it literally means if we follow the service rules, the notice could be delivered to the law enforcement officer. And therefore the spouse, it would satisfy the service rules. And that means it would, under our Maryland rules, by delivering it to the law enforcement officer, and therefore the spouse may never know about it. I mean, candidly, this was my sort of old gripe. I don't think the details have been fleshed out on this.
And I think that you can take that debate to the floor. We've talked about it this morning. I understand your concerns. We can take the debate to the floor and that's where we'll have it.
Mr. Chair, I'd like to move the bill.
Yeah, there's a motion on the bill.
Second.
And a second. All right. We are on Senate Bill 627. Okay. I'm going to do a roll call. The Vice Chair.
Yes.
Delegate Arakan. Delegate Bartlett.
Yes.
Delegate Cardin.
Yes.
Delegate Conaway.
Yes.
Delegate Cox. Delegate Crutchfield.
Yes.
Delegate Deborah Davis.
Yes.
Delegate Juanita Fisher.
Yes.
Delegate Grammer. Delegate Griffith. Delegate, where are you? Okay,
Yes.
Delegate Rachel Jones.
Yes.
Delegate Lopez.
Yes.
Delegate Malone. Delegate McComas.
No.
Delegate Moon.
Yes.
Delegate Shetty.
Yes.
Delegate Cham. Delegate Watson.
Yes.
Delegate Williams.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 votes, it passes. All right, that concludes this voting session of the House Judiciary Committee. We are going to the floor at 6 o'clock. Thank you.